Namaskar, dear students. I am Dr. Vibha Sharma, Associate Professor in Government Law College, Ajmer. After looking into the various aspects contained in your syllabus under the subject of victimology in the paper Penology, Victimology and Forensic Science, which is prescribed for the final year students, today we would be seeing the aspect relating to compensation to the victims and their rehabilitation. Before starting with this particular aspect, which of course forms the final part as far as your syllabus is concerned, I would definitely like to share certain aspects because these matters actually should be approached with the sensitivity that the subject demands. So, as we are aware that every crime produces victim, and the victims are generally considered as mere informants or witnesses in criminal trials. That is to say, that they assist the state in its endeavor to punish the offenders, actually are now becoming the focal points of our criminal justice system, thanks to the groundbreaking reforms in the approach of legal systems, not only nationally but also internationally. The criminal justice system is basically meant to redress the victimization of these victims and to address the issues surrounding them. The last few decades, as I've told you just now, witnessed groundbreaking reforms, not only statutorily, but also in the judicial approach towards the victims of crime. So, victim compensation is one of the major aspects in reparation of the harm or injury caused to the victim due to the commission of the crime. And we all are aware that the monetary assistance in one way or the other always helps the victim in the mitigation of their sufferings. So let's start looking into the legal aspects of compensation and rehabilitation as contained in the Indian criminal justice system. We already have seen some of the important judgments of the Supreme Court of India, giving us the constitutional perspective on the compensation and rehabilitation of the victims, taking recourse to Article 14 and 21 of the Constitution of India. However, there are other provisions also which can be said to be the foundations of principles of victimology in Indian constitutional jurisprudence. So other than Article 14 and 21, we find Article 39A, Article 38, Article 41, and Article 51A. Let's look into them one by one. The right of access to justice under Article 39A and principle of fair trial mandate right to legal aid to the victim of the crime. It also mandates protection to witnesses, counseling and medical aid to the victims of the bereaved family, and in appropriate cases, rehabilitation measures, including monetary compensation. Of course, the provision on fundamental rights contained in Part 3 of the Constitution, directive principles of state policy given under Part 4 of the Constitution, form the bulwark for a new social order in which social and economic justice would blossom in the national life of the country. We are aware that Article 41 mandates inter alia that the state shall make effective provisions for securing the right to public assistance in cases of disablement and in other cases of undeserved want. And of course, Article 51A makes it a fundamental duty of every Indian citizen, inter alia, to have compassion for living creatures and to develop humanism. Of course, if emphatically interpreted and imaginatively expanded, these provisions 39A, 38, 41, and 51A can form the constitutional underpinnings for victimology. To have the correct perspective, it would be worthwhile to go through one or two judgments which were pronounced by the Supreme Court of India in the earlier times, like the one pronounced in the case of Maruram and others versus Union of India and others in the year 1981. None other than the pioneer protector of the human rights, Justice Krishna Iyer. This judgment was followed in Ankush Shivaji Gaikwad versus State of Maharashtra in the year 2013. One of the other important judgments to be pronounced by the Supreme Court of India in this regard, we will learn more about it in the later slides. So Justice Krishna Iyer, in this case, speaking for the court, said that while social responsibility of the criminal to restore the loss or heal the injury is a part of the punitive exercise, the length of the prison term is no reparation to the crippled or bereaved, but is futility compounded with cruelty. Victimology must find fulfillment not through barbarity, but by compulsory recoupment by the wrongdoer of the damage inflicted, not by giving more pain to the offender, but by lessening the loss of the forlorn. We find that in the year 1988, the Supreme Court of India, in the case of Harikishan and State of Haryana versus Sukhbir Singh, which was also followed in Roy Fernandez versus State of Goa and others in the year 2012, the court pointed out that Section 357 of CRPC is an important provision, but courts have seldom invoked it, perhaps due to ignorance of the object of it. This section of law empowers the court to award compensation while passing judgment of convicting. In addition to conviction, the court may order the accused to pay some amount by way of compensation to the victim who has suffered by the action of the accused. Now, this power to award compensation is not ancillary to other sentences, but it is in addition thereto. It was highlighted that it is a measure of responding appropriately to crime, as well as reconciliating the victim with the offender. So, it is to some extent a constructive approach to crimes, and therefore it is indeed a step forward in our criminal justice system. So then it is important for us to know as to what do we actually mean by the term compensation when we talk about the criminal victim relationship, and why compensation as such is required. So the term compensation in present context means amends for the loss sustained. Anything given to make things equivalent, a thing given to make amends for loss. It is a sign of responsibility of the society, which is civil in nature, representing a non-criminal purpose. So compensation is used in relation to a wrongful act which caused the injury. Literally, it means the money which is given to compensate for loss or injury. And we are aware that the whole purpose of compensation is to make good the losses sustained by the victim of a crime, or by the legal representative of the deceased, or who has suffered pecuniary loss or non-pecuniary losses. It is, in a way, counterbalancing of the victim's sufferings and loss that result from victimization. So we can very well say that in criminal victim relationships, compensation concerns in making amends to the victim, or perhaps it is simply compensation for the damage or injury caused by a crime against the victim. We are aware that victim compensation, if successfully meted out, retains the equity between the injured and the injurer, since justice not only requires punishment to the accused, but caring for the victim and also protection of the victim's rights along with the support in times of distress. By doing so, the victim gets somewhat satisfied and he or she feels sense of belongingness and security in the society. Generally nowadays, the modern world has almost discouraged the reimbursement to the victim by offender or his family. In fact, the states generally have a compensation scheme in the statutory books. In India, in the Criminal Procedure Code of 1973, the relevant provisions are Section 357, Section 357A, Section 357B, and Section 358. Among many reports, 142nd, 144th, 146th, 152nd, 154th, and 156th are very important reports which have made very important contributions towards compensation of victims. Considering the need for care and rehabilitation of the victims, in the year 2008, by way of an amendment, Section 357A was added in the Criminal Procedure Code, in which victim compensation scheme had been introduced. So the object of the said provision is to provide power to courts to direct the state to pay compensation to the victim where the compensation under Section 357 is inadequate, or where the case ends in acquittal or discharge and the victim is required to be rehabilitated, or when the accused is not traced but the victim has been identified, or where no trial has commenced. So as you can see, the various aspects have been covered under Section 357A. In 2013, new additions by way of 357B and 357C were also inserted in the Criminal Procedure Code of 1973. Now we will quickly go through the provisions contained in the Criminal Procedure Code of 1973, which relate to compensation and rehabilitation of the victims. We find that Section 357 provides for an order to pay compensation. I hope you remember that in the previous slides, we already have seen some of the important aspects which were observed by the Supreme Court in the case of Maruram as well as in the case of Harikishan. So let's see as to what this section provides. We find that in this section, there is a provision for expenses in prosecution, then compensation to the victim, then compensation in case of death, and also compensation of victim in other offenses. So all these things have been taken care of. So let's see. Here what is provided is that when the court imposes a fine or a sentence, including a death sentence, then two situations may arise. One is when fine forms a part of the sentence, and the other is when fine does not form a part of the sentence. So We will first of all see as to what happens when the fine forms a part of the sentence. Then the court may order the whole or any part of fine recovered to be applied in defraying expenses incurred in the prosecution, in the payment to any person of compensation for any loss or injury caused by the offense, when, in the opinion of the court, it is recoverable by such person in a civil court. So that is compensation to victim. Then, if the accused is convicted for causing death of another person or abetting it, then the compensation to the persons who are entitled to recover damages under the Fatal Accidents Act of 1855, they will be given the compensation for the loss resulting from such death. So compensation in case of death, and then compensation of victim in other offenses. Now, if the accused is convicted for any offense which includes theft, criminal misappropriation, criminal breach of trust, or cheating, or of having dishonestly received or retained, or have voluntarily assisted in disposing of stolen property, knowing or having reason to believe the same to be stolen, in compensating bona fide purchaser of such property for the loss of the same, if such property is restored. So even the purchaser, in case is the victim or will be affected because of the restoration of the property, then to that person also the compensation will be meted out of the fine which will be recovered. Okay. Now, in the situation where the fine does not form a part of the sentence, then the court may still order the accused to pay by way of compensation specified amount to the person who has suffered any loss or injury by reason of the act for which the accused has been so sentenced. Clear? So in both the situations, when the fine forms a part of the sentence, and also when the fine does not form a part of the sentence, the order to pay compensation may be passed by the court who is imposing a fine or a sentence, including a death sentence. Now, it is to be noted that this section itself provides that this power is not limited only to the trial court, but while exercising powers in revision, the appellate court, high court, or court of session may also pass an order to pay compensation under this section. However, we should note that such payment is to be made only after the period of appeal has elapsed or after the decision of the appeal. Clear? Then we come to section 358, which provides for compensation to persons groundlessly arrested. The section clearly provides that whenever any person causes a police officer to arrest another person, if it appears to the magistrate by whom the case is heard that there was no sufficient ground for causing such arrest, the magistrate may award such compensation to the person so arrested by the person who caused such an arrest. However, the amount of compensation is not to exceed 1,000 rupees. So now if it was only one person who was so arrested, then the compensation will be given to such person for his loss of time and expenses in the matter. If there were more persons than one, then again for each one of them, such compensation will be given for the loss of time and expenses in such matter. Now, all the compensation awarded under this section are to be recovered as if it were a fine, and if it could not be so recovered, the person by whom it is payable shall be sentenced to simple imprisonment for such term not exceeding 30 days as the magistrate directs, unless, of course, such sum is sooner paid. Okay. Now we will see the provisions which were inserted by way of an amendment in the Criminal Procedure Code of 1973, which relate to compensation or rehabilitation of the victim or their dependents. Coming to Section 357A, we find that it provides for compensation and rehabilitation of the victim or his or her dependents. It emphatically mandates that every state government, in coordination with the central government, shall prepare a scheme for providing funds for the purpose of compensation to the victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. Then we find that the section provides that whenever a recommendation is made by the court for compensation, the District Legal Service Authority or the State Legal Service Authority, as the case may be, shall decide the quantum of compensation to be awarded under the scheme referred. Then we see that the section clearly provides the situations when the court may make such a recommendation. Now, if the trial court at the conclusion of the trial is satisfied that the compensation awarded under Section 357 is not adequate for such rehabilitation, or where the cases end in acquittal or discharge and the victim has to be rehabilitated, it may make recommendation for compensation. We further find that the section also provides that an application may be made by the victim or his dependents where the offender is not traced or identified, but the victim is identified, and where no trial takes place. In such situations, the victim or his dependents may make an application to the state or district legal service authority for award of compensation. Now, on receipt of such recommendations made by the court or on the application of the victim or his or her dependents, the state or district legal services authority shall, after due inquiry, award adequate compensation by completing the inquiry within 2 months. It also further provides that the state or district legal services authority, as the case may be, to alleviate the suffering of the victim, may order for immediate first aid facility or medical benefits to be made available free of cost on the certificate of the police officer not below the rank of the officer in charge of the police station or a magistrate of the area concerned, or any other interim relief as the appropriate authority deems fit. Please keep this aspect also in mind. Of course, an important judgment was pronounced by the Supreme Court of India in 2013, as I shared with you in the earlier slides. And the judgment was pronounced in the case of Ankush Shivaji Gaikwad versus State of Maharashtra. After the amendments relating to compensation in the Criminal Procedure Code, while taking cognizance of several cases related to compensation, the Supreme Court observed that the award or refusal of compensation in a particular case may be within the court's discretion, but there exists a mandatory duty on the court to apply its mind to the question in every criminal case. It further held that application of mind to the question is best disclosed by recording reasons for awarding or refusing the compensation. A very important judgment indeed, isn't it? Then we come to yet another judgment which was pronounced by the Supreme Court in the year 2014 in the case of Suresh versus State of Haryana. Apart from other considerations, the court also covered the aspect of interim compensation. The court observed that the schemes specify maximum limit of compensation, and subject to maximum limit, the discretion to decide the quantum has been left with the state or district legal authorities. However, the award of compensation has not become a rule, and interim compensation, which is very important, is not being granted by the court. It also observed that upper limit of compensation fixed by some of the states is arbitrarily low and is not in keeping with the object of the legislation. It emphasized that it is the duty of the courts on taking cognizance of a criminal offense to ascertain whether there is tangible material to show commission of crime, whether the victim is identifiable, and whether the victim of crime needs immediate financial relief. And on being satisfied on an application or on its own motion, the court ought to direct grant of interim compensation, subject to final compensation being determined later. Okay? The court further held that such duty continues at every stage of a criminal case where compensation ought to be given and has not been given, irrespective of the application by the victim. It also observed that at the stage of final hearing, it is obligatory on the part of the court to advert to the provision and record a finding whether a case for grant of compensation has been made out, and if so, who is entitled to compensation and how much. It further held that gravity of offense and need of victim are some of the guiding factors which are to be kept in mind, apart from such other factors as may be found relevant in the facts and circumstances of an individual case. The court further directed that a copy of this judgment be forwarded to National Judicial Academy so that all judicial officers in the country can be imparted requisite training to make the provision operative and meaningful. Most certainly, a very important judgment pronounced by the Honorable Supreme Court of India. So now we come to these other two sections which were inserted by way of an amendment in the Criminal Procedure Code of 1973, which relate to compensation, and of course the other one relates to the treatment of the victims. Section 357B clearly provides that the compensation payable by the state government under Section 357A shall be in addition to the payment of fine to the victim under Section 326A or Section 376B of the Indian Penal Code of 1860. And then again, it actually addresses the issue with sensitivity, that the cases where the treatment is required to be given to the victims. Section 357C provides that all hospitals, public or private, whether run by the central government, the state government, local bodies, or any other person, shall immediately provide the first aid or medical treatment free of cost to the victims of any offense covered under Section 326A, 376, 376A, 376B, 376C, 376D, or Section 376E of the Indian Penal Code of 1860 and shall immediately inform the police of such incident. I really hope that the aspects relating to the compensation and rehabilitation of the victims have been clarified to all of you, and you have understood this part of victimology very well. So then now I actually come to an end of the parts that were to be covered under the topic victimology. My next video definitely would deal with the probation as well as parole under the topic of penology. I really hope that all of you are actually doing very well and taking very good care of yourselves. Please take very good care of yourselves and all the best for your exams. Thank you so much for listening to this video of mine. God bless you all. Bye.